their dad was having an affair with 6 women and got one of them pregnant.
I totally get that this is emotional. They won't see the affairs in the same way as you do.
How are the needs of children considered in financial order?
Great question. Finances can be really impacted where we've got children involved. How impacted they are depends on...
Will the judge turn around and say, oh, but why is she getting more? Or is it that we've agreed it and it's fine?
No, not at all. His decision is probably based on guilt. And okay, your housing needs are then met, but are his.
If the child doesn't want to go to see the other parent, do they have to?
You never want to be forcing a child to do something it doesn't want to do.
Is it the same both ways? They didn't want to go to the parent's house most of the time, would that be the same thing?
That's a bit more of a serious concern. Why is it that they don't want to be with the main carer? Hi everyone, welcome back to the Legal Queen live show. I am Tracy Maloney, your host, aka the Legal Queen. I am also a practicing family law solicitor with over 20 years of experience. Over the years, I've helped hundreds of people successfully win their divorce, finance and child custody matters. If you think you would like some help, then please join me on the Discord. On with the first caller.
Hi, can you hear me?
I can, yes, hi.
So I've got 2 children.
Yes.
A 1-year-old and a 13-week-old.
Yes.
I found out their dad was having an affair with 6 women and got one of them pregnant.
Okay.
A week after my youngest was born.
Okay.
So he did a runner, fell off the face of the earth, basically. So I have applied for a C-100 form.
Yes.
To the court. For a passport, live with order, and a name change form. It's only for my 1-year-old.
Yes.
Because he didn't turn up for the littlest birth certificate.
Yeah.
But my thing is, what will happen if he doesn't turn up?
Well, if he doesn't turn up, I think you'll definitely get your live with order because they are very young babies and they're living with you. So if he doesn't turn up, the court will assume that, you know, he's not challenging you for that. He's disappeared off the face of the earth, as you've said, although it has only been 13 weeks or however long. But so I suspect that you'll get the live with order, even if it's only in the interim to begin with. The name change, I suspect that they'll adjourn it off for the name change and they'll want him to attend. So it might be adjourned and then another hearing listed to deal with the name change. In the event that he still continues not to turn up, it will come down to the evidence that you're giving in support of your application as to whether you'll succeed. The passport, I think you're fairly safe there. You know, to be honest, when you're applying for a UK passport, you don't really need a court order anyway. I think you only need one parent's signature. And as long as you give the passport office enough information as to who the parent is, you will be able to get the passport. So the passport and the live with order, I don't have too many concerns, and I think you'll get those. But the name change, I think the court would probably want him to be involved only because they won't see the affairs in the same way as you do. Okay, I totally get that this is emotional and absolutely morally off the chart, but the court's going to be looking at it through the eyes of the child. You know, is it in the 1 year's best interest to not have dad's name or to keep dad's name, regardless of how many women he's slept with? And that's essentially how the court's going to be looking at it. So for that reason, I suspect they're going to want to speak with him.
That's fine. Can I, if I do add, obviously he said he doesn't want anything to do with the kids.
Yes.
Will that obviously have a
it won't count if you're saying it, because obviously you could just be saying it. But absolutely, if he turns up to court and says, I have no objection, I don't want anything to do with the kids, and yet they can live with her, she can change their name, that she can have the passport, then the court will say fine. In that instance, the court may then look to you and say, why are you before the court? If he was in agreement to all this, you didn't need to make the court application. So I would...
He hasn't been, because we've been going through his brother. He is refusing to speak to me.
Okay.
And he's just being difficult because I've asked numerous times about, will you just give me full custody then if you don't want anything to do with him?
But he's already done
And-
that. Essentially, he's already done that because he's walked out on you. He can't give you, legally, he can't give you full custody because he doesn't have those powers. But by virtue of the fact that he's not living there and he's not being involved with the children, he has handed over that responsibility to you. So you are by default the live with parent. Okay, so he has already done that, really. Silence says that, okay? With regard to the name change, if you want to do that via deed poll, ask his brother to give him the papers and see if he'll sign the papers for the name change. And the same with the passport. You know, you don't need his signature for the passport. So it might be that actually this C100 application doesn't need to go any further.
I'll say, yeah, I've done that. And that's where he's saying no. He said, if I try and take him abroad, that it'll get me done for abduction.
Okay. So when you are making your application for the live with order, then just ask for another clause there that you are able to go on holiday for, you know, up to 28 days per year, which is the standard at any one time throughout the year with both of the children, and just get that in the order, because that's then not abduction.
That's fine. Will it be okay, obviously, that I haven't put my little girl on there?
Yeah.
Because he's not on the birth certificate for
Well,
her.
but that's only for the name change. If you're asking for the live with order, it doesn't matter, because he could make an application. He's the biological dad. So he could make an application for parental responsibility, regardless of the fact he's not on the birth certificate. That doesn't matter. So, you know, I would be including your little one because you want her to be part of the order for the holidays anyway.
Okay.
All right.
No, that's perfect. Thank you very much.
Absolute pleasure. Thank you. Bye-bye.
Generally speaking, how much is the overall cost from the moment you send off a C100 application
Yes.
to the completion of the first court hearing for a child arrangements order without legal aid?
Okay, so great question. For those of you on TikTok, how much is the children's process? If you are representing yourself, then all you are going to pay is the court fee, which for children's has just gone up. And I need to print myself off an updated price list. They went up end of April. It's just over £300 now, I believe. Yeah, that's right. So that's all it's going to cost you if you're representing yourself, because you pay that upon submitting the C100 form to the court. There are no other charges for hearings. You know, you can have 10 hearings for that price if that's what the court deems necessary, or you could have 2 hearings for that price. So it doesn't matter how many hearings you have moving forward. The only other additional cost that you will have, of course, is if you get a solicitor. If you have legal aid, then you don't pay for that legal advice. But if you don't qualify for legal aid, the cost of legal representation could be anything, because then it depends how much time you need from that solicitor. You know, I've run cases where they've run into tens of thousands of pounds, and I've run into cases where they've been a couple of £100 because all they've needed my help with is to help them with draft the form. So you are in complete control of that.
And I've just had a look online, Tracy. It's £263, the new fee for C100s.
Thank you, Captain. 264. It must be the finances that have gone to over 300. So 264 is the price for the C100 when you're submitting it to court. Thank you for that.
No worries. That's all I've got for now.
Okay, lovely. Ansi, let me come to you. Now, we had a little chat last week, so welcome back.
Hi. Hi. It's just actually a question to you. Maybe you can suggest some approach I can, handle this dad with. So actually, I had to move away from my house because he was abusive and stalking. but my family still lives. We used to live in the same city, but my family still lives in the same city as him. So I keep obviously coming back. Now it's half term. I'm back again with the child. We have a court order in place. If you remember, it's still like in the supervised contact center till end of June, and then we are to agree on a parenting plan. But he keeps texting me because I don't know if he keeps coming to check the house or someone sees the car or me in the town. It's the small, like kind of town. And then he keeps texting me that like these, I wouldn't call it abusive, but it's not in a nice tone, like, if you hear, why don't you tell me, and no blah blah, like, we should, I am able to see the child, and you just lying. I'm not speaking to him, so I'm just wondering if you know any approach how I can approach these type of situation, because yeah,
Sorry,
if we are normal co-parents.
Ansi, can I just jump in? What
Yeah.
situation? I'm not really understanding
So
the
the
question.
situation is that we have this court order in place where he's only allowed to see the child 2
Yes.
hours every Sunday
Okay.
in a supervised contact center.
And is he
And then
having,
now-
hang on, slow down. Is he having that contact each week? 2 hours in the contact
Yeah,
centre?
he does have that,
Okay.
yes.
And,
Yeah.
and outside of that, it will be any further contact as can be agreed between the parents. So if he is contacting you and you don't want that contact, is that your question? What can you do about that?
And my question is that how to deal with it, because in my understanding is that we have the order in place for another month, and then we're gonna jump onto the parenting plan
Yes.
in a nice situation if
Yeah.
we agree, which is preferably gonna be only weekends because of the school commitments and then his work commitments.
Yeah.
So why is he asking me these questions? I know you
Okay.
don't know the answers.
No, I don't
what
know.
can I
Yeah, I don't know the answer to that, Ansi. And what you're asking me is actually an advice question, which I obviously can't answer you specifically on this public forum, because people will handle it in different ways. Some people will just ignore. Literally just ignore him. If he wants more contact than 2 hours each Sunday, let him make a further court application. Okay. Other people will be intimidated by this constant texting and calling round and may ask the police to step in and perhaps think about getting a harassment notice. Depending on what he's saying to you and what sort of content you are getting from him in emails or text messages, it may warrant some advice on a non-molestation order. So it really does depend. And obviously I don't want you to share that with me here. That's where it kind of steps over the line into you requiring some advice. But it really does depend upon the type of contact you are getting from him.
No, this is helpful because he's minding his words now, because I've repeatedly reported him before because he was like sending me back to my mom and all these things, So, but he's now, behaving in the text messages, so there is nothing it's just not a nice tone. But yeah,
So
it is
just-
helpful because
yeah,
ignoring maybe
Yeah,
the best.
I think just ignore him. Eventually,
Yeah, okay.
hopefully, he'll get bored and move on to somebody else.
Hopefully.
Yeah.
Thank you very much.
Pleasure. Thank you, Ansi. Thank you. Captain, you are off mute. You have another question for me, I take it?
Do. So we have an order in place for my husband's children, but mum is not following the order.
Yes.
We enforced the order and she has been given unpaid work, but is still not following the order. The next court date is in September, and the enforcement mentions a possible change in residency
Yes.
if mum does not follow the order.
Yes.
What can we do to push for this?
To push for, well, the matter has to go back to court. Now, let me explain. A penal notice is one thing. A change of residence is another. So whilst mum is in breach, is it mum that's in breach? Sorry, Captain.
It is mum that's in breach.
So whilst mum is in breach and penalties are being given, to do a complete change of residence is going to require more evidence. We can't just we won't succeed on a change of residence because mum's been naughty and hasn't been sticking to the other order. Everything is considered in the context of, is it in the child's best interests? So I think that's important to understand. And then from there, you would simply make a further application to the court for a change of residence. That's how it would start. But I don't want this person to assume that because mum's in breach of the order, that application will succeed.
Yeah, just going back to the question,
Yeah.
The enforcement mentions about a change in residency.
Okay, so a change of residency will be considered, I'm sure is what it says, in which case you're off to a good start. You know, the application will certainly be considered in the context of the breach, but it doesn't mean that it will be successful. And look, it might be. I just wouldn't want to say, I wouldn't want my answer to be absolutely make the application and we'll have, you know, the change of residency all completed by Christmas, because they're really hard applications. And of course, the judge that made that order may not be hearing the new application. It might be another judge or magistrates who actually take a different view to that. But by all means, they should make the application for a change of, if they feel that's in the child's best interests.
Tracy, the lady that's got her hand up in the audience,
Yes.
Erin,
Yeah.
she might have some information for you. She was the one that I was just asking the question for.
Oh,
you know,
okay.
about the change import order thing.
Great. Well, I'll invite her up to the stage now. Thank you for that, Captain. Erin, you are on mute. Whenever you are ready, take yourself off mute and ask me your question. There we go. How can I help?
Sorry, it's the first time I've used this.
That's
I
okay.
didn't know how to use it.
That's okay.
So we do have some more evidence for the enforcement order and the change of residency.
Okay.
So when before it was enforced, there was 3 contact sessions that were allowed by mum. And the contact notes are really positive in regards to the relationship that he has with the children. And it was also noted that she has no boundaries with the children and is not encouraging the relationship.
Yeah. And your question,
So I just wondered whether that will have any sort of impact with the evidence that we have for the residency.
Yeah, I mean, as I said,
I've got going back to court in September. That's from the enforcement.
So I have to be careful because I can't give you advice. Okay, that's the first thing. You're not a client, and this question is typical of an advice needing question. Okay, so I do have to be careful, and I can't answer you in a bespoke manner. All I would say to that, though, is that it's difficult to prove to a court that the other parent isn't encouraging contact. It's really difficult to do that because you'd almost have to be there and video mum saying, I don't want you to go and see dad this weekend. Do you know what I mean? And that's really hard. So whilst you think you have evidence, and I'm sure that you do, again, I would just be nervous to put a lot of weight onto it without having an appointment. Do you know what I mean? It's really hard on this public forum to be bespoke because I can't be. So I don't want to be negative and say your evidence isn't any good, but equally I can't say, yes, you've got great evidence there. So by all means, make the application. Put forward to the court what you have. If you can get a one-off appointment with either us or somebody else, then do that because at least we'll be able to.
Does that mean that we have to make a separate application to court, or does that just follow with the enforcement?
So what's the application before the court at the moment? Just an enforcement?
No, so we done a C100 in March 2023.
Right, but you can apply for 3 things on the C100. So what's the application before the court?
A child arrangements order.
Okay, so it's not for residency, I take it.
No, so that the residency's only been mentioned by the courts since the enforcement.
So just know that the court's only going to make an order in line with any application before it. If there is no application before it for residence, it won't make an order for residence, chances are, because it hasn't been asked to. If you're already in proceedings, don't do another C100, do a C2, which is an application that we use to make a further application when we're already in court proceedings. And on the C2, you are now formally asking the court to make a residence order. And now the court has the power to ask for all kinds of evidence and different bits and pieces to help it make a decision as to whether that's in the best interest of the child.
Amazing. Thank you so much.
Pleasure. Okay, thanks, Erin. Bye-bye.
Thank you. Bye-bye.
I'm just going to ask you a question now that I've seen on a lot of your comments and videos lately, Tracy,
Yeah,
and it's about the terminology we use: lawyer, solicitor,
yes.
barrister.
Yeah, absolutely. Great
I know
question.
interchangeably, but I just thought
Yeah.
maybe you could tell people what they all mean.
Yeah, absolutely. So in England, we have barristers and solicitors. So solicitors tend to do the paperwork. We are face to face with clients and we stay with clients from beginning to end. We are more office based. And barristers are advocates. So they are constantly in court. They typically don't take instructions from members of the public, whereas the solicitors will. Barristers will take their instructions from their solicitor, their instructing solicitor. So barristers are typically, you know, wigged and gowned, although they're not in family court, but typically they are and will constantly be in court. Solicitors are more office based. The term lawyer, it's American essentially, because in America we don't have. Well, it's not, I shouldn't say it's American. I mean, lots of countries use the term lawyer, but in America, they don't have solicitors and barristers. They have lawyers, and lawyers do it both. So lawyers will be office-based and do the role of a solicitor, but they will also do all their own advocacy as well. And their terminology is lawyers. And sometimes in the UK, I'll often introduce myself as a lawyer because I will do both. And most people understand what you mean when you say a lawyer. But strictly speaking, that's the difference between the two. 3. Mags, how can I help you? What's your question?
Can you hear me? Sorry, it's the first
I
time I'm
can.
using this.
Yeah, what's your
Yeah,
question?
thank you. So we're applying for a divorce online ourselves, and it's come to the point of the conditional order. The question we had is we're both in agreement about finances, the house, and what to do with it. I had a conversation with him about getting a financial order. Now he was worried that will the judge turn around and say, "Oh, but why is she getting more?" Or is it that we've agreed it and it's fine?
No, not at all. So when you reach an agreement and you send it into court, this is very similar to my first caller of today. You are effectively asking the court to make the order because you want some power behind that order. So now it becomes the court's order. And the court will only make an order if it feels it's fair and reasonable. And that, of course, is the legal standard of fair and reasonable. That's not what you and your husband consider fair and reasonable. So a lot of times the court will either ask for more information, a little bit more background, because on the face of it, it may look unreasonable or unfair, or it might simply reject it. So this is why I will always suggest that even if you don't want a solicitor to draft everything or to do everything, at least have a one-off appointment so that you can be sure the order you're putting before the judge will be approved.
Okay. Because if the only asset that we have is the house, but he's
Yes.
agreed because of the reason why we're divorcing, he's happy for me and the other one, the little one, to have the majority of the equity, and he's happy with that because he's taken fault, whatever, between us.
Yes.
We were just thinking, oh, but what if the judge turns around and says, why is she getting more? Or why is he giving her?
And the judge may well say that because his decision, if I may be honest, is probably based on guilt. Whatever he's done, he's now decided, right, you can have all of the house. The court won't agree with the decision made on guilt. The court will want, because you're asking the court to make an order, so it's the court's order. So the court will want to know that it's fair and reasonable. And okay, your housing needs are then met, but are his. Yeah. So it may be that it asks for more information. If the court does ask for more information, please don't say to them, well, because it was his fault the marriage broke down, and he says, you know, I can have the house, because the court will definitely reject it on that basis.
Right. Okay.
All right.
So get some legal advice on how else to go around it, or what
absolutely. Even just a 1 hour. Because, you know, if you were to speak to me sort of off air so that we could have a private discussion, I might be able to say to you, well, if you explain that he has a pension, for example, but you're not touching his pension and you're getting all of the house, in those circumstances, the court might say, oh, okay, yeah, that seems to be fair then. We'll go on that basis. Okay?
Okay.
All right.
Yeah. So when I'm doing the online request for an hour for some legal advice, can I put that request it with you, or do I just leave it like, will they just let me know whoever's the most available?
You
Okay.
can request it to be with me. I will forewarn you though, right now I am so backed up with clients that it will be a while. So I will be suggesting that you see one of my team. But you know, they're all amazing, or they wouldn't be on the team. So rest assured, you'll get some good advice.
Okay, brilliant. Thank you.
All right. Thank you,
Thanks.
Mags. Bye-bye.
Hi, my ex-partner recently took me to court. I have been taken to the first court hearing, and in a few weeks I'm expecting my next court date. But I'm just wondering, do you know, like, what would happen and like what to expect?
Well, first of all, what application is it for? Children or finances?
Her children's C100 form he started off with.
Okay. And what's he asking for? Contacts?
Yeah.
Okay, your connection's quite bad there, Summer. I can't hear you very well. So you've already had the first hearing, and I assume that some homework was given. Perhaps Kafkas were asked to do a Section 7 report, maybe.
Yeah, they sent me like on this like course online to do,
Right.
for us both to complete.
Okay.
And then so I've been like back and forth with meetings with Kafkas and stuff.
Yes.
But like I've not really got a clear understanding on what to expect.
Sure. I mean, always know that you will still retain some form of control. Your voice will be heard in court. So if he's asking for more contact than you think is suitable, let the judge know that. Always let the judge know of your view. Okay. Kafkas's role in all of this will be to make their recommendation to the court as to what they think is suitable in terms of contact. So it might be that they've spoken to you, they've spoken to Dad. They may not agree with what Dad's asking for. They may not agree with what you're suggesting, and maybe they'll hit it somewhere in the middle. And then effectively, the role of the court is to hear all three opinions. So your opinion, or what you say is correct, Dad's opinion and Kafkas's opinion, and then the court will make their own decision. If you and Dad still can't agree, they will make their own decision, but only at a final hearing. Okay, so if your next hearing, Summer, isn't a final hearing, then the court won't make a decision then.
I just had a quick one. So we're busy going through a relocation order. And my ex was previously living with his two other adults and his girlfriend. Before we have Kafkas coming round, he's now changed his housing situation where it'll just be him and his girlfriend, so it looks like a more child-appropriate household. Will the court see this as reactive? Because I don't know if this is a permanent situation or if he's just doing it to make the house look better for Kafkas coming round, and it's just whether or not the court will kind of see how they will perceive that.
It's difficult, isn't it? Because the other take on that is that will the court see it as him really trying? You know, him really cleaning up his act, sorting himself out. So that's difficult for me to answer, if I'm honest, without knowing anything about the case. But what I would say is that, as I said to the last caller, your view is really important to the court. So if you feel that this is for show, or that this isn't genuine, or it's driven by some other motivation to simply have contact and then go back to old habits or ways that might not be in the child's interest, let the court know of that. How you convince the court of that is to say to the judge something along the lines of, and this isn't the first time this has happened, Judge. You know, if you can, of course, you may not have other examples, but it's difficult to know. If you feel when you're in court that the judge is slightly going towards him, then put your own suggestions forward, because that's the whole point of court. Court want to hear different opinions. It helps them in making their decision, as long as they're supported by evidence and it's not just a tit for tat. They don't want to encourage that.
Yeah. Okay, great. Thank
All
you.
right. Absolute pleasure. Thank you.
Does a tenants in common agreement on a property stand in divorce? Short marriage, 2 years. I made large deposit on the family from the sale of my home. No contributions made by my husband. I'm hoping to fight for that now in the divorce.
Right. Well, let's start at the top. Tenants in common, for those that don't know, is where you hold the property in, it can be unequal shares. And effectively what it means is that if you die, your share will go to whoever is your beneficiary in your will. It won't automatically pass to the other owner of the house, which usually is your partner or your spouse. If you hold the property as joint tenants, then that's usually in equal shares. And if you die, your 50% will automatically pass to the other owner of the property. But when we're going through a divorce, and let's say that we hold the property, husband and wife, hold the property in unequal shares as tenants in common, then yes, absolutely, the court has the power to depart from that. Let's say that the ownership is 80-20 because one of you put in more of the deposit. But to give the 20% to the one spouse would mean that they are homeless or destitute. Absolutely, the court has the power to move away from that. To specifically answer this question, though, Captain, he did say that it was a very short marriage. So the only other thing that I would add to my answer is that the shorter the marriage, the more that you are going to walk away with what you brought to the party. Okay, so if it is a very short marriage, chances are the tenants in common, unequal shares will hold.
And just to follow on from that, Tracy,
Yeah.
you talk about short marriages, medium marriages, long marriages.
Yeah.
Can you just quantify what the law classes in those areas?
So short marriages would be sort of 1, 2, 3, 4 years. Medium marriages are sort of between 5, 6, 7. Longer marriages then are heading into sort of the 8, 9, 10. Definitely anything over 10 is long. When we get really long, when we get sort of into our late teens and 20s, we are even it's harder, sorry, I'm trying to think of the right words. It's harder to ring fence the premarital stuff because the longer the marriage, if you've been married for, let's say, 20 years, 25 years, it's very hard to ring fence premarital because what we then say is that they've been absorbed into this long marriage. But yeah, hopefully that helps. So sort of 4 years and below would be short. And then 8, 9 years and above would be long. And anything in between would be sort of mid-length.
Hi. So I am co-parenting with a shift worker, and he doesn't want to contribute for childcare. He only wants to pick him up on his days off. So it means that he's constantly being pulled out of childcare, and I'm footing the cost for that, which I don't mind because I want him to have that time with him. But I don't sort of know how to arrange contact with him because it changes every week.
Yeah.
And he has a younger brother, and it's just really disruptive for us and for him. And I don't know the best way to go about it. I still want him to have that contact, but he's being pulled out of childcare.
It's difficult, isn't it? It's difficult with shift workers because, as you say, their shifts are constantly changing as well. I think that my answer would have to be from the eyes of the child. So it always has to come back to what's in the best interests. And whilst having a relationship with both parents is incredibly important, of course it is, also consistency and routine is important. So as much as he is or she is a shift worker, what you're going to have to try to agree between you both is that there has to be some core hours where they know they're going to be available for contact. And let's try to build a framework around that. And if they are off for hours in addition to that framework, it may be that for those particular hours, the child is left in the nursery or wherever they are, because it can be disruptive and upsetting if, the child doesn't have a routine as well. So balance, I suppose, is what I'm trying to say.
Yeah. So what would that look like as an example? So what would sort of like the core hours look like?
Well, what are the shift? What's the shift pattern that they do? What's the hours of the shift pattern?
So they do 4 on, 4 off. They do 2 day shifts, 7 till 7, and 2 night shifts, 7 p.m. till 7 a.m.
Okay.
But he refuses to have him on the days that he works. He only picks him up on the days off.
Okay, so then we have no set pattern when it comes to days, because if we're 2 on 2 off, then them days are going to change every week. But the core hours on the days off could be set. Do you see?
Okay.
So we could say that, look, regardless of whether you're off Monday, Tuesday, Wednesday, Thursday, or Friday, Saturday, on your days off, you are having contact, or I suggest that you have contact 10 till 2. Or 10 till 6, or whatever it is. So you can't maybe set the days, but you can set a framework of hours on the days that he is having contact. That's where I would suggest you start. It's more of a co-parenting issue, really, because you just use the words he's not in agreement to. You know, it's difficult, and you may be being met with resistance because he might be saying, you just don't want me to see the child. That's not it at all. You just want some consistency for both him and the child, but more importantly, the child. So I would suggest that you just say, look, on your days off, and that they fluctuate, they're different, but let's at least set regular times on the days that you are off, because you know those, you know what they will be.
Yeah.
Yeah.
Perfect. Thank you.
All right. Pleasure. Thanks so much.
Hiya.
Hello. How can I help?
Yes, I've got a question. Me and my ex-partner have had a child arrangement order for his daughter. We split up for the good reasons. His child was living with me for a bit. She'd been sent to her mum. Her mum didn't return her to me. I've received the court papers. And my question is, do I have to really fill in the court papers and attend the court?
If you're named as a party, then my suggestion would be yes, because you've been named, you've been served. But it depends what it is that you are looking to achieve. I mean, I don't know, and please don't read out the contents of the application. But yes, if you have been joined as a party to proceedings, then that means that the court's interested in what you have to say. And I assume that's because the child was living with you for a while.
Yeah, that's where I'm struggling at the moment, because obviously I want what's the best for the child.
Yes.
But obviously we are not with her dad.
Yes.
And obviously I don't know that it's on the cards for us to get back together.
Yes.
So that's when my confusion is, what's the best for me to do?
Absolutely. So your input to the court might simply be that, you know, whilst I'm not with the father anymore and I asked to be removed from these proceedings because you don't have parental responsibility, and, you know, you're not a biological parent, you could perhaps give some insight into the child's relationship with the mother, maybe. But I think that as soon as you say to the court at the first hearing that you're not with the father anymore, there's every chance that you'll be released from those proceedings.
Right, okay.
Yeah, unless, of course, you were making an application to have ongoing contact with the child, but you're probably not. So I suggest that if you ask to be released, you will be. But by all means, go to court, or if it's the first hearing, it might even happen via Teams, and let them know. If you just simply don't turn up, then the court won't have insight to what we've just spoken about, say, and you'll continue to be joined as a party.
Because obviously I don't have a solicitor myself.
Yeah, that's okay.
And then I forgot now what I was meant to ask.
That's okay. What I would say is it's a great question, Kat, for others that are listening. It doesn't matter that you don't have a solicitor. You can attend court on your own. Family court's a private court, so you can actually attend without a solicitor and just represent yourself. That's fine.
Yeah. Well, I'm just in progress to fill in the court papers.
Yes.
And obviously it's so much for me to understand. I've never been in this situation before.
Okay.
But obviously, like you said yourself, I just want to know what's the best for a child.
Yes.
And obviously my children.
Yes.
As well, because we've got our children together as well.
Yes. I would say, Kat, do your best. with the paperwork. The court's not going to be marking it. It's just going to give an indication. So just do your best and send that back to court.
Right, lovely. Thank you very much.
Pleasure.
That gave my mind a rest a little bit.
Good. That's good. Thank you for the question, Kat. Bye-bye.
Just a little bit of advice. I finished court proceedings for grandparents' rights.
Yes.
And it's all finished now. But my son went for his order as well, and so they merged the cases together. The mother got legal aid due to domestic violence between herself and my son.
Yes.
So that means, because we got merged together, that means that obviously she got legal aid for both of us. But since then, my son has withdrawn, so he doesn't have contact at all with his daughter. If it was to return back to court, would she still get legal aid with me?
Yes. Well,
she would.
Well, so hang on. I said that a bit quick. It depends on the timeline. If you have a legal aid certificate and you are dealing with a contact matter and you were joined as a party, then yes, it will continue so long as the legal aid certificate hasn't been shut down and dealt with. Because then if the certificate was all shut down, then she'd have to reapply. And because there would be no domestic violence between you and her, she may fail to get that. But if it hasn't been shut down yet, you're reopening the case, her solicitor hasn't quite finalised the legal aid bill, then yes, they could reopen it because it deals with the same child.
Yeah, right, okay, that's fine.
All right.
That's all I wanted to know.
Okay. Okay, you're welcome.
Thank
Bye-bye.
A couple of finance questions for you, Tracy.
Sure.
How are the needs of children considered in a financial order?
Great question. Housing needs is the first one. So obviously children will be living with one or other of the parents. So let's say they're living with mum, and typically they do. Before I get jumped on for saying that the courts favour the mums. But typically they do. So it might be that mum gets a slightly bigger share of the equity from the house because she has the responsibility of housing the children. Income needs will need to be addressed. So maybe the person that's looking after the children can only work part-time. So, you know, their income is stretched. And maybe the court make an order that the other parent pay some additional maintenance. I'm not talking about child maintenance through CMS. I'm talking about additional court-ordered maintenance. So finances can be really impacted where we've got children involved. How impacted they are depends on how much mum and dad are earning and how much equity we have in the marriage to be able to provide for everything.
Does the ages matter, Tracy?
It does, because if we have really young children, sort of, 9 and under, let's say, there's a long time before they're going to reach 18. Whereas if we're going to court and we've maybe got 2 15-year-olds, we're not going to get anywhere near sort of 70 or 75% if we've got responsibility to house the children. In that instance, we might get, say, 55% because actually we've only got the responsibility of housing them until they're 18. So the closer they are to 18, the less of a move away from 50% you're going to get.
Okay. Next question on finances. If a judge decides that they want a hearing for a financial order, what does that usually consist of?
If the judge decides. So I'm going to guess that the reason the judge has called them in is because an order has been sent in, maybe a consent order, and the judge isn't quite sure that if they make the order, it's going to be fair and reasonable. And sometimes it does depend judge to judge. Some judges will simply write back and say, give me more information on this. Other judges will say, can I just call you both in for 15 minutes and just hear verbally from you? I want to hear verbally. When you go to court, the recorder's switched on, so it's recorded and judge can get a better understanding of why the parties arrived at this agreement. But if judge requests it, it will be the 3 of you in the courtroom, nobody else. And it will just be for you both to give your view. Maybe judge wants to make sure that you both understood it, and that there's no duress taking part here. Nobody's being bullied into signing it.
Yeah, okay. And just a quick one for you, Tracy.
Yeah.
Because I know we've talked about court a lot in today's podcast.
Yeah.
When people think of court, they think of what they see on Coronation Street, for example.
Yeah.
The family court looks very different to a criminal court, doesn't it? Could you tell people what the court looks like for family law?
Absolutely. So family is private for a start. By contrast, criminal is very public. So in criminal, you not only have your jury, but members of the public can wander in and just sit in the public gallery and watch. In the interest of the public, they're encouraged to do so. Family is completely the opposite. It's very private. It will be you and the other party. Any legal reps, so 2 solicitors potentially or 2 barristers, but if you haven't got legal reps, it will just be the 2 of you, and then the judge. Sometimes it's not always a judge. Sometimes we can have magistrates, maximum of 3 magistrates. Sometimes it's just a legal advisor who's doing a bit of gatekeeping, but very, very private. Nobody else is allowed in with you. Even if you brought a friend or a mum or a dad and you said, oh, please, can they come in? Chances are the court's going to say, no, they can't come in. It's a private courtroom. And it's a great question, Captain, because a lot of what I do is to help people who can't afford legal representation. And whilst they can get the information from me and my website and my channels, they then feel very intimidated about going to court, but know that it's a very small, closed environment. Even the courtrooms are designed to be less intimidating. So a lot of times they are large conference rooms with, big dining tables in the middle of them, as opposed to the bench, which is, again, what you see on TV, slightly raised, slightly higher than where you would sit. They're not like that, really, family courts at all. They're more welcoming than that.
There's no wigs and gowns, is there?
No. Oh, that's the other thing as well. Yeah, thanks, Captain. So in crime, all our barristers are wigged and gowned, but in family, they're not. In family, we just wear suits or smart dress. And again, the idea is that it's just less intimidating for members of the public.
Yeah. I have got another question if you've got time, or if you want to go to someone else.
No. I've invited HMC up to the stage, but I think they're having some difficulty. So yeah, fire away.
Okay, so this is, hello, I'm looking at moving back down to be closer to my family for support. I'm in Lincolnshire at the moment and needed to be moving down to Kent to be closer to all my family. His dad does not like the idea of this. What's the best thing to do? Do I need to apply to the courts? He currently sees the children every other weekend, Friday after school until Sunday afternoon. But he works on Sunday, so only really sees the kids on the Friday after school and the Saturday. I offer him to have them for the half terms too, but he always says it won't benefit him because he will be at work, so it will be down to his girlfriend to have them. He has also threatened me in the past to take the kids if I move. I don't want to move for him not to see them. It's about me having my family around me for support. I will happily make arrangements for him to see the children in the half term and summer holidays. Can you help me at all?
Yeah, look, it based on the question, it's got a real strong element of success to it. When you make the application and it's for a relocation order, really, because you're moving out of the area and that's going to have an impact on Dad's contact. But the reasons for making the application are solid, and it happens a lot where a couple split up. And one of them wants to move back to familiar surroundings where they grew up, where their family are, etc. So it has all the hallmarks of being a good application. In order to just put the cherry on the top, explain how you are going to ensure that the child's relationship continues with father. And it may not look as it does right now, alternate weekends or every weekend, but they are still going to have a relationship. It's just going to have a different look and feel about it. And that's what I think needs to be explored there. Also, try mediation first, because it might be that the other parent is just having a bit of a tantrum at the moment. It's upsetting the apple cart. And, typically humans don't like change often. So mediation could perhaps, and it will be quicker too and cheaper mediation, but it may help to bring about a resolve without the need of a court application.
That's great. Thanks, Tracy.
Pleasure. HMC, let me come to you. I'm just going to take you off mute. Away you go. Oh, you're on mute now. Take yourself off mute and ask me your question.
Hello, am I on?
Hello, you're on, yeah.
Right, so I have a question. If the child is obviously if they have alternate weekends, if the child one weekend, let's say they're about 12, okay?
Yes.
If the child doesn't want to go to see the other parent that weekend,
Yes.
do they have to, or is it their decision, or do the parents, or can the parents force them to go?
So you never want to be forcing a child to do something it doesn't want to do. The order says, usually the orders are worded, the parent will make the child available, you know, alternate weekends or Tuesday after school or whatever. So the court order will never say the parent must force the child to go to school, you know. But at 12, I would encourage the parents to be listening to the child, because at 12, now they're starting to develop their own life. You know, they might have some clubs that they want to go to on Saturday morning, you know, after school clubs or out of school clubs. They might have friends, you know, they might be on a sleepover Friday night and don't particularly want to be, you know, rushing away to see the other parent. I know when mine was small, they would be playing computer games on a Saturday morning, or they'd be out at football, you know, and they weren't interested in me or their dad, quite frankly. They just wanted to be doing their own thing at 12 and 13 and 14. So at that age, I would really be encouraging parents to try and put your differences aside, sit down and really focus and work hard at the co-parenting.
Yeah, okay. And another question I
Sure.
have is when it comes to the when it comes to the child,
Yeah.
let's say 12 again. If they let's say if the parent who has them like most of the time,
Yes.
if they're with the person who has them 90% of the time,
Yes.
let's say that is it the same both ways? So because I was talking about an example, they didn't want to go to the other parents who has them less of the time, but if they didn't want to go to the parents who has them most of the time, would that be the same thing, or would it differ?
That's more of a serious question, because if a child is living with a parent for 90% of the time, obviously using your example, what I think you're getting at is that when they're with the other parent for all the alternate weekends, they don't want to go back. So then that's a bit more of a serious concern, because why don't they want to go back? You know, they're living with this parent essentially, and from what you're saying is the child is saying, I want a change of residence. But so in that instance, I would say that there is a more serious concern, and I would be wanting the parents to speak with the child. Thank you. To speak with the child and understand why. Why is it that they don't want to be with the main carer, or they're a bit reluctant to go back?
Okay, thank you.